Welcome back to RealClear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. This week, we examine contemporary issues in the rule of law, both in the U.S. and in Africa. In the second half of our show, we'll speak with Donatien Adu from Cato Institute Afrique and dig into his efforts to establish a blockchain-based land registry in the Ivory Coast. Up first, we're pleased to welcome Andrew Grossman back to the program, appellate litigator at BakerHostetler and adjunct scholar at the Cato Institute. Andrew, welcome back to the show.
Well, thank you for having me.
Andrew, as the Obama administration comes to an end, I asked you back on to look at the way in which new laws are being made outside of the legislative process defined by the Constitution. And before we get into individual areas, take us through the laundry list of extra constitutional tactics that the modern presidency uses to make laws, everything from executive actions to dear colleague letters to sham, sue, and settle.
When you think back to civics class, you think Congress passes a law and then the president signs it. But in this past administration, it seems that all the lawmaking activity has really occurred within the executive branch. You've got executive orders, you've got regulations, you've got dear colleague letters, you have interpretations of regulations, you've got settlements of lawsuits. Really, there's just a wide variety of executive actions, not merely what we would think of historically as executive actions, but all kinds of things.
How is the Obama administration compared to previous administrations when it comes to making laws like this outside the bounds of the Constitution?
In terms of aggressiveness in the executive branch, we've never seen anything like this. At the beginning of his second term, President Obama was quite blunt that he's got his pen and he's got his phone and he was going to take action without going through Congress. And indeed, that is exactly what he's done. There really is no historical comparison to it.
I've seen compilations of executive orders from prior presidents before, and some of them had a pretty heavy hand.
You can't just look at the number of executive orders to get a sense of whether a particular presidential administration is abusing executive power. Many executive orders are legitimate because they may simply implicate the operations and organization of the executive branch. Those aren't controversial. What we're talking about here are the types of actions that often don't even appear in executive orders at all. They can be regulations, they can be interpretations of regulations, they can be interpretations of statutes. There are all different kinds of executive actions that if you just look at a count of executive orders, they don't show up.
And we have a whole parallel administrative law system that reinterprets laws also, don't we?
That's exactly right. Again, everybody thinks back to Congress making the law, but really where so much of the law is made nowadays is in the administrative agencies. They act on petitions from the public and from special interest groups, but more often than not, they act on their own accord. They have a particular goal in mind, a particular policy that they'd like to see in place. And if they can find any potential hook in a statute, that's something that they can attempt to do through regulation. And so we've seen wild reinterpretations of long-settled laws coming through these agency processes.
And lawsuits that come up through administrative law judges follow different rules than criminal or civil law judges, right?
Well, that's exactly right. There's been a lot of controversy over the past several years about the Securities and Exchange Commission hearing more and more insider trading cases in its own administrative courts with administrative law judges who work for the agency rather than in neutral and independent Article III courts. A lot of people believe that it really gives the government an unfair advantage when it not only is enforcing the law in court, but it's writing the law and then seeking to enforce it in its own courts.
Why do you figure the Supreme Court has become so supine when it comes to insisting that laws only be made by Congress?
Here's where a little bit of historical perspective makes sense. If you look back to the late 70s and the early 1980s in particular, there really was a lot of what people would call judicial activism on the courts, where you had many judges taking a very loose view of the judicial role and interpreting statutes in ways to impose legal obligations that seemingly came from nowhere other than the judge's own imaginations. And in many instances, rejecting legitimate executive actions by the administrations in place at that time. The response, particularly on the conservative side of the political spectrum, was for the courts to be increasingly deferential to administrative agencies. And you've got two legal doctrines that really play into that. One is called Chevron deference, and the idea is that a court will defer to an agency's seemingly reasonable interpretation of an ambiguous statute. And the other is called our deference, which means that a court will defer to an agency's seemingly reasonable interpretation of its own regulations.
Andrew, let's run through the major areas where Obama has attempted to remake America. Start with energy and the environment.
Energy is something that the president started off with in 2009 with the idea that he would implement through legislation a cap-and-trade system for carbon dioxide emissions and effectively make the federal government the regulator-in-chief of our nation's entire electric system, something that historically has been regulated primarily by the states. That didn't pass. Congress refused. There was really no interest in it. And so the administration came back a few years later with something called the Clean Power Plan to make EPA the regulator in the first instance of the entire electric system. Now, the problem is there was no statute. All you had was the Clean Air Act, and it doesn't give EPA the authority to do that. But they found something. Relying on this idea of Chevron deference, they looked around and they found this very old, basically forgotten provision of the statute that nobody had really used in years. And they gave it this very strange interpretation that, in the EPA's view, allowed it to simply take over this entire sector of the economy and impose the very same type of system that Congress rejected.
How has that approach fared in court?
Well, from the EPA's point of view, they really took a gamble, and the gamble didn't pay off. Back in February of this past year, the Supreme Court actually stayed the Clean Power Plan, in other words, putting the entire regulation on hold, something that is really an unprecedented action. But commensurately, the regulation itself was unprecedented. And so I think the Supreme Court's action really speaks to the justice's dubious view of the agency's legal authority.
How about health care? Beyond the so-called Affordable Care Act that was actually passed by Congress, and which does appear to be heading for repeal or reform, how has the Obama administration gone beyond the text of the law to remake health care policy?
So you've got this statute, the ACA, that gives the administrative agencies that are supposed to be running it just unbridled and unprecedented discretion in terms of how it is this will actually work. And apparently even that wasn't enough. You've got a couple different areas where the administration has really had to stretch the language of the statutes, in some cases past the breaking point. One is in terms of delaying the imposition of the statute's mandates, that includes the individual mandate and the employer mandate. They recognize that there would be an enormous political backlash, and so they simply put them on hold and instituted all kinds of administrative exceptions, things that the statute never contemplated, so as to avoid corrective action by Congress. Another is the very controversial birth control mandate, something that has been administered in a way that denies many religiously sensitive employers the opportunity to decide what types of drugs they're going to provide to their employees when some of those drugs they believe, according to their religious beliefs and otherwise, may constitute the provision of abortifactants. And then you've got these weird regulations that channel money to insurance companies so that they continue to participate in these Obamacare exchanges. The money has never been appropriated by Congress, but the administration's point of view seems to be, so sue us, see if you can stop it. That's what the House of Representatives actually did in the end, and they prevailed in that. They convinced the district court that these particular expenditures of money to pay off the insurance companies were actually illegitimate under the law.
What about banking and finance? It's been rather astounding to see significant portions of these heralded multi-billion-dollar banking settlements being funneled off to fund social advocacy groups.
It seems like every other week you read in the newspaper about one or another of the financial regulatory agencies or the Department of Justice reaching a settlement with some bank or financial firm and socking them for tens or hundreds of millions of dollars in costs under some vague statutory system. They lent too much money or they didn't lend enough money. Either way, you still get fined by the government. At this point, the administration has taken unto itself, under Dodd-Frank and other statutes, so much authority that basically they view these companies as their piggy banks, and they don't only direct the money to government activities that they favor, but in many instances to third-party organizations that Congress has refused to fund. Some of these are very politically controversial groups that engage in all kinds of activism that many people may disagree with, and that, again, many members of Congress disagree with, and specifically have precluded funding of these groups. It raises very major constitutional issues because Congress is supposed to be the one appropriating the money. But to date, at least, it's been very difficult for anybody to do anything about it.
Andrew, when reviewing the extra-constitutional tactics used by the president to make law, immigration policy looms large. How has the Obama administration fared on that front?
Well, the Obama administration has really taken the executive discretion that's inherent in enforcement of the immigration laws to new heights. And I don't think that's a controversial assertion. First, you had the Delayed Action for Childhood Arrivals program known as DACA. That program provided deferrals in enforcement of immigration laws with respect to illegal immigrants who arrived in the United States as children. And then more recently, you had the far more controversial DAPA program, which extended the same protections to potentially millions of individuals present in the United States at this time. That action, of course, was blocked by a district court in Texas as simply violating the president's authority under the immigration statutes, as well as potentially running afoul of the president's constitutional duty to see that the laws are enforced. That decision was upheld by the Fifth Circuit Court of Appeals, which continued to enjoin this DAPA policy. And the Supreme Court ultimately split over it 4-4 after the death of Justice Scalia. But we've never seen anything like this, where you have a fundamental change in immigration policy, something that Congress has been considering in all of its many details for a period of years. And the president's response has been, well, if Congress isn't going to enact this very major change in policy, I'm just going to do it myself with a stroke of the pen. It really is unprecedented.
So what about higher education? A tremendous brouhaha has been kicked up on campus thanks to the Obama administration's reinterpretation of Title IX. Remind us what Title IX is and what caused all the controversy.
Title IX, on the face of it, is a relatively uncontroversial statutory system that simply provides that educational institutions that receive money from the government have to treat members of the different sexes equally. That's it. There's really nothing more to it than that. But what the Obama administration has done here is taken that very sensible and equitable principle and extended it to all kinds of realms of policy decisions that were really never contemplated. You've got one that requires, this is a 2010 Dear Colleague letter. In other words, simply a letter that was sent to administrators of colleges that requires that these different schools undertake anti-bullying programs and prohibit all kinds of touching and sexual comments, jokes, gestures, graffiti. And if they don't enforce those prohibitions with a heavy hand, they risk losing all federal funding. That was followed up by a 2011 Dear Colleague letter that required not only that you have those types of prohibitions, but that all of these potential things constitute sexual violence that have to be adjudicated, if they're alleged, that have to be adjudicated by the school in these administrative procedures by a preponderance of the evidence standard. In other words, if you have an alleged date rape on campus, that's something that not only does the school, rather than the criminal system, have to adjudicate it, but the school has to do it in this kind of kangaroo court run by school administrators and faculty members, while imposing against the defendant, the person who's accused, a much lower burden that would prevail in any other type of proceeding. The result has been chaos on campuses where you have so many schools being sued by oftentimes men who have been thrown out of college based on sometimes very unfair procedures, adjudicating alleged date rapes, unwanted touching, and all the kinds of cases that in many instances, even in the courts, are recognized to be somewhat ambiguous in certain instances.
And I understand the accused don't have the customary right to counsel or cross-examination or any of those protections.
That's exactly right. Some schools have taken the position that allowing somebody who's accused to have access to a lawyer, allowing them to examine the alleged victim, simply providing them the normal due process rights that our Constitution guarantees is something that would violate Title IX. And so it's really perverse when you think about it. The government's statutory position here under Title IX is that you can't give people what we would view in every other context to be their constitutional rights. And schools have to do this because they receive money from the federal government. It really is perverse, and it's something that a lot of courts have looked at askance in individual cases.
And this was all done with a Dear Colleague letter or Dear Colleague letters from bureaucrats.
That's exactly right. Simply a letter. And in many cases, we haven't even had the benefit of a letter. In some regulations under the Affordable Care Act, we've had regulations by blog posts where a new statutory interpretation has been adopted by the posting of a blog post online. In other cases, you've had emails. At this point, under the Obama administration, it basically seems like anything goes. When they'd like to adopt a new statutory interpretation or a new requirement for a regulated entity, it could come in any particular form, not the kind of notice and comment rulemaking procedures that the law has traditionally mandated, and certainly not any type of legislative enactment as our Constitution contemplates and in many instances requires.
Labor law seems to be a favorite area for mischief making. What's been unfolding there?
The Obama administration has been particularly aggressive in the labor law and employment law area. In one instance, there was something called the persuader rule that required businesses to disclose all the attorneys and other service providers with whom they may work with concerning labor issues. Of course, that would seem to violate not only the First Amendment, but traditional attorney-client privilege protections that an employer can get advice from a legal counsel, and that's something that traditionally they wouldn't have to disclose. The benefit of this, of course, for labor unions is that it gives them an opportunity to pressure companies not to work with particular law firms. It gives them an opportunity to pressure particular law firms, and it gives them leverage that they can use in the collective bargaining process. Very recently, you've had the expansion of overtime payment requirements under the Fair Labor Standards Act. And that's something that the courts have viewed as being such a radical expansion and clashing so far with the statute that immediately before it was scheduled to go into effect, the district court put the entire expansion on hold. So this is something that's going to have to be reconsidered by the next administration. But it's something that, I think fits with this pattern where you've seen this enormous overreaching in so many different areas. And you've seen more court decisions against these and staying these things and joining them, blocking the administration going forward than we've seen under any previous administration. 8 years ago, this would have been unthinkable. Now it's become the status quo.
So, Andrew, we have a new president taking office in January, and there doesn't appear to be any indication that he'll be any more restrained by the Constitution than Obama was when it comes to wielding executive power. Across the issues we discussed today, energy and the environment, healthcare, banking, immigration, higher education, labor law, how can Donald Trump use Obama's tactics to undo his legacy?
I think it's fair to say, live by the sword, die by the sword. If the president had gone to Congress and enacted all of these different policies in the way that our Constitution contemplates, it would be hard for an incoming administration to change law. He'd have to go back to Congress. But that's not what the Obama administration did. And what it means is that the Trump administration, upon coming into office, can begin to dismantle the entire Obama agenda. Regulations that were promulgated through notice and comment rulemaking can be undone through notice and comment rulemaking. Some of them can be blocked immediately through executive action, executive orders and memoranda and other types of administrative action, even while they remain on the books as they're being undone through administrative proceedings. Things like Dear Colleague letters can simply be disavowed. Regulations and other actions that are currently subject to litigation can be the subject of settlements, under which the administration might simply throw its hands up in the air and say, you know what, we agree with the people challenging these actions. I think at the end of the day, the Obama administration relied on so many aggressive statutory and regulatory interpretations that it's very easy for the incoming Trump administration to simply look at all of these actions and say, you know what, we don't believe that we have the authority to do what's in this policy. And that provides them with a perfectly acceptable and even reasonable and legitimate basis to say that they're not going to follow the regulation and they're not going to follow the action, whatever it may be.
So you've outlined sort of a fair and square way to do it. But if Obama's been making laws with blog posts, why can't Trump make laws with tweets?
Well, first of all, how much law are you going to get in 140 characters? If he begins doing tweet storms, God help us all.
One of the things that might be fun to watch now that the parties have switched roles and, he who used to have the upper hand is in opposition, are we going to see record levels of hypocrisy on both parts?
I think the answer is that a lot of conservatives feel very deeply about the proper role of the executive branch, the proper role of Congress, and this headless fourth branch of government, the administrative state. And so I think that there's going to be less opportunity for policy drift than were things changing the other way around. That said, I think it's very important at the outset of this administration, before it's undertaken any actions whatsoever, to distinguish between two types of actions, one of which is legitimate and the other one of which might raise questions. In my view, undertaking appropriate administrative actions to undo the overreaching of the Obama administration, particularly where it relied on very tenuous and in some cases unbelievable assertions of legal authority, All of that's perfectly legitimate, and that's something that a president can do consistent with his powers. If the president is saying, I don't believe that we have the authority under the statute, under the Constitution, or otherwise to carry out the last administration's policies, that's an appropriate position to take because it's a limitation on executive power. The more problematic instances may come to rise where a Trump administration uses the same tools that the Obama administration used to enact its own preferred policies rather than working with Congress. At least so far, some of the signs that we've seen have been positive. It seems like many would-be members of the Trump administration have been in close communication with House leadership and are working on a very aggressive legislative agenda. But at the end of the day, that's where the big decisions need to be made in Congress, not in the executive branch.
So if you had to predict what's going to happen in Trump's first 100 days, what would you predict?
In the first 100 days, I think it's obvious that we're going to see a complete dissolution of the entire Obama administration agenda. In recent months, people have been talking so much about the Obama legacy, but the Obama legacy probably won't exist in any tangible form by the time that the Trump administration's first 100 days or so are done, because so many of these actions have been undertaken in ways that they can just be easily, quickly, and expeditiously undone. In terms of legislative action, we'll have to see. A legislative agenda takes a lot of time to move forward, and there are so many details, there's so many different policy areas. Even something that seems like a discrete action like repealing the Affordable Care Act involves so many different moving pieces and transitions that it may not be possible to get it done within the course of 100 days. But at the very least, the hope would be that the new administration would set its agenda during that time period so that we know what's coming over the next couple of years. That would be an appropriate way to get going.
Well, Andrew, we certainly live in exciting times. Once again, we really appreciate you coming on to give your perspective. Thanks for coming on the show.
Oh, it was my pleasure. Thank you for having me.
That was Andrew Grossman from BakerHostetler here on RealClear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. RealClear Radio Hour is a not-for-profit, donor-supported program produced in conjunction with RealClear Politics, America's premier independent political website. Today's program was partially underwritten by the generous support of Donors Trust, the donor-advised fund committed to promoting a free society. For more information, visit donorstrust.org. Ahead, we'll speak with Donati Naidoo from Cato Institute Afrique to discuss his efforts to bootstrap the rural economy of the Ivory Coast by establishing a blockchain-based land registry. Stay tuned.